Today, we're honored to have with us a distinguished guest, an officer of the Indian Railway Personnel Services batch of 1992. Our guest has also served on central deputation as Joint Secretary in the Department of Justice, Ministry of Law. He played a pivotal role in the implementation of the ambitious Ecourts projects. He also has been an invitee member of the E-Committee of the Supreme Court of India from February 2020 to February 2025. During one of the most challenging periods in recent history, his leadership helped steer the judiciary through the COVID-19 lockdown, enabling courts across the country to continue functioning through unprecedented digital transformation. Thank you, Mr. Pravash Pandey, for joining us here today.
My pleasure and my privilege to be here. Thank you.
So, can you tell us what is the Ecourts project, and did the pandemic accelerate the implementation of this project?
Well, the Ecourts project was started by the Government of India way back in the year 2006. It was part of the National Plan on E-Governance, which was formulated by the Ministry of, by the planning departments basically. And it was already rolling, and although it was in a very, very experimental mode, it picked up steam somewhere around 2010 when the Ecourts phase 1 was started, in which the government started a consolidated plan for computerization of all the courts all over India. When the pandemic happened, by the time we were already into Ecourts phase 2. So a lot of the work had already been done.
Right.
But of course, it was more of a showcase by that time because people were not really relying on it all that much. Now, when COVID-19 happened and the courts were shut, suddenly that was the only means which was available before the judiciary to continue with the work. And I'd like to place on record the excellent work which the Indian judicial system has done. Because when entire world, the court system had stopped, at that time, Indian courts have had a disposal of 63%. When there was no physical courts being held anywhere. That was entirely due to the Ecourts project and the efforts made by all the people who were involved behind it.
Oh, wow, that's commendable, sir. So what was the problem with the current court system that led to the initiation of this digitalization of the courts?
Well, the biggest problem which is being faced right now, and it is well known to everybody, is the huge pendency. As on date, we are having 5 crore plus cases pending in the courts, out of which maybe 4.5 are pending in the lower courts. So we have this huge pendency, and as per a report of the Niti Aayog, it will take 126 years for clearing this backlog. So we really need to do something. We needed to do something drastic,
right,
so that we could actually at least work towards getting all this pendency cleared.
Right.
Apart from that, there is also the concept of ease of justice which is coming up, and of justice as a service, because it is a basic democratic right of the citizen to get justice.
Absolutely.
Now, if we make the court system so complicated and cumbersome that he is not able to get it and he has to wait for so many years, so we are defeating the entire purpose.
That's a system failure then.
That is a system failure, because we have basically inherited the setup of the colonial masters,
right,
and we have simply continued with it. Interestingly, the British have changed it totally, because we were there in England. We have seen their system. They have changed it totally. In fact, it is nowhere close to what we are doing.
Okay.
But we are. It's like जो हिंदी में कहते हैं ना कि चेला गुरु जो था वो गुड़ रह गया, चेला चीनी हो गया. So we are better colonials than the colonials themselves.
Correct, sir. So in fact, that was supposed to be my next question. So was there any part of this digitalization that we took from the other countries?
No, actually, when we did an analysis, the digitization which has been done in India is in fact, in many ways, it is better than the other countries. Of course, there are some portions which are not yet done, some areas where other countries have gone ahead. Like, for instance, getting copies of judgments, etc., which are authorized. These authenticated copies of judgments, etc., these have gone further ahead in many other countries. Otherwise, we are quite well placed.
Okay, wow, nice. So could you please briefly describe your roles and responsibilities while you were steering this project?
Well, I was the designated mission leader for the Ecourts project, Now, because this is the Ecourts project is a joint venture between the judicial system as well as the government of India. Because technically speaking, the judiciary and all the expenditure which goes into the courts, that is part of the state list. It is to be borne by the state.
Okay.
But as an exception, the government of India decided to totally to own this project and give the funds directly in a central sector scheme. And in that way, it's quite heartening to see that over the past 10 years, the government of India has already pumped in almost close to 12,000 crore rupees
Wow.
in this entire project. So I was representing the government of India and also ensuring that the money was spent in a manner which would be properly utilized, and also give some kind of guidance about the rules and regulations so that the project would be facilitated further.
So what were the key challenges that you had to face while you were trying to implement this technology in the judicial system?
Well, what we realized once we started interacting with the judiciary was that unlike government departments, the judiciary does not work in a hierarchical structure. So every high court is free to make its own decisions, especially in these matters. And also the structure of the Ecourts was that it was in a core and a peripheral model. So the core was decided centrally, but the periphery was left to the high courts to decide on their own. In a way, it was good because it was allowing them to innovate on their own. But at the same time, it was a problem because many of the high courts decided to totally branch off in a separate direction and also go in for systems which are not compatible. So when you're talking digitization, you assume that at one point of time you will reach a stage where entire country is on a same platform, so that information can seamlessly travel across all courts, all levels. Now, if you have systems which are built as silos, which will mean that ultimately your transfer of data gets interrupted. So this was one of the major challenges.
Okay.
Again, very unfortunately, the first movers did not have the advantage. In fact, the first movers ultimately had a disadvantage. Because what happened was, for instance, Delhi High Court and also Madhya Pradesh High Court, Bombay High Court, these were some of the early courts which started computerizing.
Okay.
So they started off in a time when the software was different. Now, when Government of India came into the picture, National Informatics Center came into the picture, then they developed a common platform which was used by the other courts. But then this happened at a later date. So the software which they used was yet further advanced.
Correct.
So we ended up with a situation that those people who had taken the trouble of computerizing early ultimately ended up with a system which was not compatible with the rest of the country.
They face a disadvantage initially.
Yes. So initially that was a problem.
And they all have to shift over to the next process?
Yes. We had to ultimately change over. It was possible to onboard them.
Okay.
But then it took an effort. There was a substantial amount of time when these systems were actually not able to interact.
Okay.
So now, of course, that has been now.
They're integrated.
They're integrated now.
So how have the judges, lawyers, court staff reacted to this digitalization? Was there any hesitation on their part, any resistance? And if yes, sir, how did you face them?
Well, we got different kind of reactions from the different people. For instance, for the judiciary, some of them were skeptical. Some of them who were tech savvy were quite happy about it. But then the most interesting reaction came from the lawyers, because I have even got threat calls from lawyer associations that your efforts are ending up in reducing my bill. So it's best that you should close shop. So in fact, this was rather surprising, because we had thought that we are trying to make the lives of the lawyers easy by making the access to information easy for them. Yeah. But on the contrary, because now it was possible for the client to directly reach out and get the information directly from the website. Right. So in a way, the lawyer felt belittled. So that was one challenge which we have always faced.
Right. So, sir, how has the introduction of technology helped the common citizen?
Well, the very intention of the Ecourts project was justice delivery and also doorstep delivery of justice. So a new concept was thought of while we were implementing phase 3 of the Ecourts project. That is justice as a service, because this is a basic requirement, basic necessity for the citizen of this democracy, that he should have easy access to justice. So now there are a wide variety of services available online. So if the person is having access to a laptop, or even if he has a mobile phone, which is on which he can download an Ecourts app, he can feed in the case numbers, he can feed in the CNR number of the cases, and he can keep getting updates about whatever is the progress in that case, what is the latest last judgment, what is the next date of hearing. Or for this kind of information, earlier he had to keep running to pillar to post trying to find out all these little details, but now he can simply get it in the form of a message on his phone.
Right.
And besides, now even that Ecourts app which I'm talking about, that has been made available for lawyers as well. So even if that entire case file, if all the details of the cases of the lawyers also are fed in, then it can keep reminding the lawyer about the next
day,
hearing and all the developments.
Right.
So that way it is very much meant for the common person, so that he can get easy access to justice regarding any matter in the court.
Right, correct. So Justice D.Y. Chandrachud has been a strong proponent in using technology for courts. So how was his vision helping the Ecourt project?
Well, Justice Chandrachud was associated with the Ecourt project throughout my entire tenure there. Initially as the chairperson of the Ecourt committee per se, and later on in the capacity of Chief Justice of India, he continued to hold that portfolio. So initially itself, when the COVID broke out, at that time, suddenly it was felt that there was no law which was authorizing video conferencing hearings to be held. So in the midst of this COVID pandemic, I think it was probably March end or could have possibly April of 2020. A VC hearing was held, which was a suo motu case which he took up, in which the Supreme Court of India passed an overarching order authorizing and giving legal sanction to video conferencing hearings, so that there was no complication later on.
Right.
So from that very time itself, the stage was set, which allowed the entire Ecourt project to roll forward, because video conferencing, which now has become pretty common. At that point of time, it was an oddity, and because for that reason now, because it had a legal sanction, then it allowed those many hearings to be held and the courts to progress even in the midst of the pandemic, when crowd gathering was not allowed at all.
Okay. So how do you see artificial intelligence being integrated into these Ecourt systems over the coming years?
Now, like all other software systems, AI is very much important for the Ecourts. Already in some areas it is being used, that is regarding the translations, etc. Because now Supreme Court also is using AI-based tools for automatically translating the judgments into various Indian languages. So that is one important area. But more importantly, what was envisaged, of course, this was at the planning stage when I left. I am not particularly aware of the current development. We had envisaged a judgment support system for the judges, in which if all the data was provided to an AI-based engine, it would analyze all previous judgments and give suggestions to the judge, out of which he could pick whatever judgment he chose. Of course, there was a lot of skepticism on this. A lot of people who were not very happy with this idea. So I don't really see a very smooth rollout for this idea as such. But then, of course, there were a lot of judges who were very, very keen about it. In fact, I remember reading in the papers that some High Court judge in Chandigarh, that is Punjab and Haryana High Court, had said that this judge had in fact publicized one particular judgment which he said he had written using AI tools.
So how would you say that the project is being regularly monitored?
Well, the monitoring structure of the Ecourt project is like this. At the apex level, you've got the E-Committee of the Supreme Court of India, which is headed by the Chief Justice of India himself as the patron. And then there is a chairperson and a vice chairperson nominated from among the senior judges of the Supreme Court. And they are assisted by the members of the E-Committee who are coming from diverse fields. And some of them, there are a couple of people who are the technical experts. There are people who give the judicial inputs, somebody in charge for the human resource development. And combined, they have periodical meetings with the High Courts, which is the implementing agency. And at the same time, at the High Court level, also you have a E-Committee, which is headed by a nominated judge of that particular High Court. And they are the ones who are actually responsible for implementation of the project. And the monitoring is done by the Supreme Court E-Committee. And also periodical checks are done by the Ministry of IT as well as the National Informatics Center.
Okay.
Especially regarding the adherence to security norms and as well as if there are any issues regarding software, etc. because the biggest thing about this project is that it has been done using free and open source software,
Okay.
which is a very big achievement because that has reduced the costing of this project by almost, you can say 80%.
Okay.
So, but then at the same time, because it is free and open source software, it has got its own pitfalls. So the system needs to be periodically audited and checked.
Right.
So that means that while adhering to the norms laid down by the NIC and also by the project monitoring done by the E-Committee of the Supreme Court of India, they, in a combined way, they ensure that this project moves on at a very fast.
Yes, correct. So, in hindsight, would you say that you would have approached anything differently while implementing this project?
Well, like all other areas, the government of India is pitching a lot for digitization in the sphere of judiciary. So before you reach out to any person for help, I'd always say that if you require any information regarding the Ecourts, regarding the judicial process or any court case or whatever, I would just advise all of you to first visit the website of the High Court or the District Court also now, and just see. It is quite possible that the information may be available there just at the click of a button.
Sir, thank you so much for being with us today. It's pleasure knowing about how the Ecourts system was implemented and accelerated during the COVID phase. As a lawyer, even I have benefited from this, and it is wonderful to have known your experiences. Thank you so much, sir, for being with us today.
It's been a privilege, and I really enjoyed the interaction with you. Thank you.
Thank you, sir.